Every day in the USA, people find themselves in court.
The affidavit indicates you told the officer that the reason why you took the vehicle was to go to Andover to get gummy bears.
Yes, sir.
Mr. Barbour, how much schooling did you have?
I have my high school degree.
You're 35 years old, have a high school diploma, and you took a vehicle to get gummy bears.
Yes, sir.
Again, asking for an OR bond.
Next case is State of Kansas versus Benjamin Barbour, case number 25 CR 371. Counsel, state their appearances, please.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Benjamin Barbour, who does appear from the Butler County Jail.
All right. Are there any announcements at this time?
Judge, I can tell the court this is a case where my client was arrested August 17 on the charge that's currently pending, criminal deprivation of property. That he's unable to make the current bond. That's why he is still in jail. I can tell the court that in speaking with him, he is prepared to enter a plea of guilty and proceed to sentencing here today with the sentencing recommendations from the defense. I can tell the court I have had certain discussions with Ms. Norris about plea negotiations. They're requesting additional time to determine restitution, which of course does present problems with sentencing if the restitution is an issue and we don't have that information yet. But my concern is my client sits in jail and can't make a bond. So, Judge, I would tell the court my client's prepared to enter a plea and proceed to sentencing. If the state is requesting a continuance for restitution, we'd be asking the court to consider an OR bond.
Mr. Regier?
Your Honor, in communications with my colleague, Ms. Norris, the state understands that there is an issue of restitution, and so the state would be requesting a bifurcation of plea and sentencing in this matter for that specific purpose.
And Judge, there's no objection to bifurcation as long as the court and the state, as long as I guess the state doesn't object to an OR bond. I mean, they're the ones asking for the bifurcation. This is a case where I believe that a different bond should be awarded if the state's asking for continuance.
And Your Honor, if the state may be heard very briefly on the issue of bond.
Very well.
Your Honor, this is a case where pursuant to the information, count one appears to be charged as criminal deprivation of property, Class A non-person misdemeanor with an attached domestic violence designation. Based off my notes from the previous hearing, first appearance hearing before District Judge Satterfield and the county attorney, it would appear that the defendant appeared in the same fashion that he does today, and the court set quite a low bond in this matter in light of the nature of the offense as a domestic violence designated offense. So the state does respectfully submit that the bond previously set by the court is more than reasonable under these circumstances, and the state would not be making any recommendations as far as modification of the bond is concerned.
Judge, if I may.
Yes.
If he is released on bond, I've talked to my client, and he would be making sure that he remains in the El Dorado area rather than live outside of El Dorado. That I can tell the court I've done the research I can for priors. I found 2 priors, both in Sedgwick County. They were convictions for misdemeanor charges, 21 CR 283, 2020 CR 2085. That in each of those cases, he was awarded probation and completed probation without warrant to show causes in either one of those, so that appears he can appear to probation officer. So even if we had the additional bond condition of reporting to probation, Judge, we're still requesting an OR bond if the state's requested a continuance in this case.
Well, I note that the defendant was living with the victims, his parents. Where would he be staying if he's released on bond?
Judge, we discussed that initially he might be in whether he's released after sentencing to probation or whether he's released on bond. Initially, he's probably going to stay at a shelter, and then start finding more of a arrangement. It is true that this occurred where he lived with his parents. He understands there's a no contact order. He can't go back there. He can't have contact with them, and he would not violate that condition, has no intention of violating that condition.
And Your Honor, if the state may be heard briefly on the issue of priors.
Yes.
Your Honor, it is the state's understanding that this is a defendant with at least one prior felony person adjudication, as well as a history.
I object to that. I've researched it. It was reduced to a misdemeanor, and he pled to a misdemeanor in that Sedgwick County case.
As well as a history of misdemeanor convictions that the court may consider relevant: theft, disorderly conduct, and criminal damage to property, as well as at least 2 prior failures to appear. So the state does maintain its position that the bond, as previously ordered by the district judge, is appropriate in this matter.
Mr. Patterson, is there any bond at all that your defendant or your client would be able to post?
Judge, I've discussed that with him. He has no cash funds available to him whatsoever.
Mr. Regier, has your office received any information from the victims concerning the damages? The affidavit indicated that the victim put the value of the Jeep in question at approximately $4,000. It was involved in an accident of some sort.
Your Honor, based off my notes, it would appear my office has had communications with the alleged victim in this case as recently as yesterday. It is the state's understanding that the issue of restitution is still in the process of being investigated and processed, Your Honor.
If the defendant wishes to change his plea at this time, I'll hear that. I won't proceed with sentencing. I will consider a bond modification. But Mr. Barbour, it's been indicated that you wish to change your plea to that of guilty. Is that correct?
Yes, sir.
Has anybody forced or coerced you in some fashion to enter this plea?
No, sir.
Are you under the influence of any medications or intoxicants?
Just my blood pressure medication.
Does that interfere with your ability to think clearly?
No, sir.
All right. Is the defendant currently on a probation or anything to that effect?
No, Your Honor.
Okay. All right. I feel, Mr. Barbour, on or about August the 17th of 2025, while in Butler County, Kansas, did you take a vehicle, that being a red Jeep Cherokee, without the permission of the owners, with the intent to temporarily deprive them of the possession of that vehicle and utilize it on your own behalf?
Yes, sir.
I find there's a factual basis that the plea is knowingly and voluntarily entered with the advice of good counsel. Mr. Regier, would your office be able to get the if we set this for September 19th for sentencing, do you believe your office would be able to get the restitution figure?
One moment, Your Honor. Your Honor, the state does not oppose setting this matter over for the September 19th setting, and the state would anticipate proceeding to disposition at that time.
All right. So does that mean you do believe that you'd be able to have a restitution figure by that time?
I would anticipate that, Your Honor.
All right. Mr. Barbour, you're 35 years old.
Yes, sir.
The affidavit indicates you told the officer that the reason why you took the vehicle was to go to Andover to get gummy bears.
Yes, sir.
Mr. Patterson, anything further?
I just want to point out what the court already knows, I think, and that he immediately alerted law enforcement when he got back with the truck that he had an accident. He was, and then when they inquired of him whether he had permission, he immediately stated no, he did not have permission. He knew that. So he's cooperated all along with law enforcement, and he's very remorseful for what happened. But we're, again, asking for an OR bond.
Mr. Barbour, how much schooling did you have?
I have my high school degree.
You're 35 years old, have a high school diploma, and you took a vehicle to get gummy bears.
Yes, sir.
I'm not going to approve an OR bond. I will set bond at $500 cash or surety. That's a reduction from 1,000. We'll set sentencing for September 19th. Anything further on this matter today?
Not from the state, Your Honor.
Very well, hearing nothing further, this matter is adjourned.